Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, we are discussing the difference between and breaking down the difference between wholesales and novations. Should be a good episode. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, like our channel and subscribe. We are on Facebook as well as on YouTube. At YouTube, you can find us at InRem Podcast. That's at InRem Podcast. Subscribe. That allows us to provide you more and better content. With that, let's go to Sean, who's going to give us our legal update.
Yeah, so today I want to talk about a recent consent order that was brought to my attention out of the state of Colorado. And so basically the attorney general in that state pursued some real estate investors who took title to property subject to the existing loans. And the attorney general's office claimed that those investors violated a specific state statute in Colorado. And we don't have an identical statute here in Arizona. We have a statute that addresses some of the same stuff as the Colorado statute, but Colorado takes it a step further and addresses what they call, or what Colorado calls, an equity purchaser, which is somebody who identifies an investor who identifies a property in foreclosure. So the property is going to be in foreclosure. And they basically negotiate the purchase of the property and whatever equity in the property for the reinstatement of the loan, and basically taking over and making the payments on the loan and buying the property subject to the existing loans. And in that case, there's certain things that have to be disclosed to the seller. So the first thing that has to happen is the seller has to be notified and disclosed of the fact that they have a 3-day right of rescission. So they sign the purchase contract, and then they have 3 days. The seller has 3 days to, sleep on that contract, to contemplate it, to seek their own attorney or own counsel, to, talk with real estate professionals, family, friends, whatever, during that 3-day period, and do whatever they want to do. And during that 3-day period, they can basically write back to the buyer and say, hey, thanks, but no thanks. And they can cancel the contract. So that's number one. The second is that the full nature of the transaction has to be disclosed. Now, that's what the statute says. It doesn't say exactly what you have to disclose. It's fairly vague on that, but it basically says that the seller has to be made aware and provide disclosures as to the full nature of the transaction. So, hey, this is being purchased subject to, the property is actually being deeded to the buyer, that the buyer is not providing any loan or financing, but it is actually, acquiring the property as basically an outright purchase, that the seller is no longer going to be the owner of the property, no longer have, right title or interest in the property, that the existing loans will remain, that they could damage their credit, that in the event of foreclosure, that can also, create, potential liability exposure, disclosure of the due on sale clause and what that means. So those are the types of disclosures that I think the Colorado statute would require. And hopefully anybody that's purchasing property subject to is using a subject to addendum that has all of those disclosures as part of the transaction. But what to me what the Colorado case highlights, and that consent order highlights, is the need to seek legal advice for every state where you're transacting. So if you're an investor and you're going to go into a state and you're going to do creative finance, you're going to do wholesale transactions, you're going to do novations, which we're going to talk about today, or even double escrows, but you're going to be in there doing transactions outside of your typical transaction, not using a real estate agent for those transactions, not using the state real estate realtor forms for those transactions. In that case, even if you have a form that you think, oh, this is good and I'm going to use it, well, you need to make sure that that form is vetted, that form is reviewed, you're receiving specific legal advice from a real estate attorney licensed in that state, because otherwise, just like in Colorado, you're going to end up being tripped up potentially by a state law that doesn't exist in the state in which maybe you do most of your real estate transactions. So for example, you and I are licensed in Arizona. We practice in Arizona. I didn't know Colorado had this statute until this was brought to my attention. I would have, maybe assumed that, it would be kind of uniform throughout the nation with maybe some exceptions. But for the most part, I wouldn't have thought Colorado would have this unique statute. And I don't know that it's unique to Colorado. It may be in other states as well, but we do know that it's definitely different than what we have here in Arizona. So it's very important from an investor perspective. Any state that you're going to transact in or you want to transact in, go and seek specific legal advice, have whatever form you intend to use, purchase contract addendums, et cetera, have them reviewed and signed off on by a local attorney, because you want to make sure that you're not going to be tripped up by a statute in that state that maybe you didn't even think would exist.
The other thing I think the real estate investor needs to keep in mind is not only are we dealing with multiple states, 50, all different laws, but we're in an industry where we've been talking about creative finance, wholesaling, novations. We're talking about a lot of different types of transactions that aren't what the public are used to as conventional transactions. So we might take these terms for granted, and today's real estate investor might take for granted these terms, but to the public and to lawmakers and to regulators, these are new ideas. And as new ideas, sometimes come fear. And with new laws and regulations come vagueness, right?
Mhm.
You already mentioned in Colorado, we've already talked about the whole laws and the wholesale laws that we have here requiring certain notifications. With new laws come, you didn't think about this, or maybe we should have thought about this. And had we thought about this, legislators would have drafted it better. And consulting a lawyer to help navigate that is even more important. I'm curious, and you may not know because, again, this is Colorado and this is somewhat developing, but how extensive is this right of rescission? So, obviously it's extensive. They have a right to rescind within 3 days, but what happens if all this takes place 48 hours before the trustee sale, not beforehand? Have they even thought about that? Have they addressed it?
Yeah, so that's a good question. So the Colorado statute provides that in the event that the seller chooses to rescind, that they have to and they will be obligated to repay the buyer any amounts that the buyer expended for the seller's benefit. So you're right. If let's say 48 hours for a trustee sale, buyer says, okay, I'm going to take my chances. I'm going to reinstate, even though that's in your 3-day right of rescission period. Seller comes back and says, yeah, I want to rescind. Well, the law provides that the seller is now obligated to pay the buyer for whatever they expended to reinstate that loan.
Okay, so
Yeah.
the buyer doesn't lose out on all the money that they reinstated, which went to another party, not the seller, right? The reinstatement figures go to the lender.
Right. So the lender doesn't have to pay the money back. The seller is obligated to pay the money, but you have a seller that's in default and
Yeah, in
distress.
foreclosure, how are they gonna
Like,
pay that?
yeah, so it sounds good, but the reality is the buyer's taking a risk if they're going to try to reinstate. So in that case, the better thing to do would be to try to obtain some form of extension on the sale for at least, even if it's a week, and see what you can do to obtain an extension would be a really good thing to avoid that very issue.
All right. Well, thanks for that legal update. Watch out there. Make sure you've got good professionals around you that are going to help you with these transactions and help you navigate the uncertainties that different laws provide in different states. With that, we're going to go into the substance of our show today. And today we are talking about the differences between wholesaling and novations. And we thought this was important to discuss because transactionally, the circumstances that give rise to a wholesale or a novation actually can be somewhat similar, and it's easy to confuse the two. So we wanted to break down just what they are, what the differences are, when it makes sense to use one, why you use one or the other. And Sean in our office does a lot of transactional work in both wholesaling and novations. So we're going to get into that. So why don't we just start from the beginning? And that are watching, Sean, are new to this idea. So let's go start with the definition. What a wholesale transaction?
So a wholesale transaction, or what the industry has defined as a wholesale transaction, is basically one in which a investor slash buyer enters into a purchase contract, and then they take that purchase contract and assign it to a third party, an end buyer, who then closes on the transaction, and then the original buyer slash investor, they receive a fee from the end buyer to assign the contract. So basically, there's a real estate transaction and there's a personal property transaction. So the real estate transaction is where you basically have a purchase contract to buy the seller's real property. However, the original buyer is not buying it. They're actually selling a personal property interest. So they're selling their right to purchase it, which is personal property. They're selling the contract. They're selling the paper to a third party who then will end up purchasing the real estate.
Which should not be confused with like a double escrow, for instance.
Right. That's completely different. So a double escrow is where the investor is the original buyer. They actually close on the property, and title will be in that investor slash buyer's name for at least a period of time. Generally, it's 24 to 48 hours. Then they have a second escrow where that buyer will then be the owner and the seller in that second escrow, and they'll sell it to an end buyer, to a third party, and close that way. So that's a double escrow. Basically, you have two escrows. So you have the first escrow where the buyer slash investor purchases the property from the seller, and then the second escrow where that buyer turns into the seller and then sells it to the third party or the end buyer for a markup, right? So, maybe the purchase price on the one escrow was 200. The purchase price on the second escrow was 250. So there's a $50,000 markup, and that's the investor's profit in the transaction, obviously minus escrow fees and closing costs and all that good stuff.
Do you think by and large, the wholesale's kind of predominantly taken over what used to be the double escrow?
Yes, it's taken over predominantly what used to be the double escrow. So, double escrows have been around forever.
Sure.
And they've changed because title companies have been more risk adverse. And so now, to complete a double escrow, you actually have to complete the first escrow and then close on the second escrow. So you have to have some level of funding in place to close on the first escrow. Versus previously, you could use the funds from the second escrow to close on the first escrow, and then within hours, you would close on the second escrow. It was like contemporaneous. It was, basically boom, boom. Now it's boom, wait a day, and then boom. But so you have to have some money. You can't take the money from the second escrow generally now and close.
Yeah. So now, given the wholesale, it's much easier to be able to, within one escrow, assign the transaction to a buyer and they're just purchasing the assignment, or the assignee's purchasing that right to do that. And by that, you avoid additional closing costs by not having the double escrow and everything else. So it's more efficient. It's cheaper for all involved.
Well, a wholesale, yeah, you avoid the double closing fees. You don't have to worry about going in and obtaining transactional funding. The only thing a wholesaler needs from a financial perspective is to basically have the earnest money deposit. So whatever earnest money they've agreed to, whether it's $1,000, $2,000, whatever amount they've negotiated with the seller, that's all that a wholesaler or a buyer who's going to wholesale needs. They don't need to find any form of transactional funding, hard money, etc., or even their own personal cash to close on the first escrow. They just need that earnest money deposit. Then they find another buyer, and then that buyer comes in, puts their own earnest money down, which then generally can result in the release of the first earnest money, and then they close, and the original buyer receives their assignment fee.
Gotcha. All right. So we have an idea of what the wholesale is. There's a lot of listeners that are listening right now that have never even heard the term novation.
Mm-hmm.
So let's talk about that. What is a novation?
So from a legal definition standpoint, a novation is replacing one contract or one obligation with another. So it's a replacement contract. That's what a novation is. In fact,
out with the old and with the new.
Yes. So we learn in contracts class in law school, we learn what a novation is. And even in real estate school, they teach you what a novation is, which is a replacement contract. That's what a novation is. So out with the old and new. In the simplest forms, you have a seller who enters into a contract with a buyer. For whatever reason, the seller and buyer are not going to close on that contract, and the seller then enters into a contract with the new buyer. And in that case, you would want a agreement in place with the original buyer, basically saying, hey, I'm going to close on this other, and we're going to novate, we're going to replace your contract with this other. So we're going to cancel your contract, and we're going to move forward with the second contract with that new buyer.
Okay, so we've got the wholesale, which is a contract. We're replacing the old with the new contract. Why am I choosing one or the others? Is this just a matter of personal preference? Maybe I've got a good novation form, so I'm just going to always do that, or I've got a good assignment form, so I'm going to do that. Why choose one or the other?
Yeah, so really it's the economics of the transaction is what's going to kind of dictate where you're going to go. So think of the novation as replacing or having the ability to replace your double escrow. And what I mean by that is when you close on a replacement contract, now the transaction is closing from the seller to the end buyer via a brand new contract where that end buyer is listed as the buyer. So you may have an end buyer who wants to live in the property. And because it's going to be their personal property as opposed to an investment property, they're willing to pay pretty much fair market value for that. And so because of that, they may just want their own contract that's different than, say, an investor contract, right? So if you have a contract between the seller and the end buyer, that will more likely be similar to your standard real estate contract with, disclosures and seller property disclosure statements, inspection period, those types of things that you find in more of your standard residential real estate purchase contract where the buyer, intends to use this property as their home or their residence. So in that case, a novation may make sense because it's like, okay, I'm going to end up, selling it to this buyer, and the buyer wants to do all their due diligence because this is going to be their home. This isn't an investor who's going to want to come in and, fix and flip. So they realize they're getting a property that's not in great shape anyway, or is going to need work, etc. So that's one. The second thing is that end buyer may want financing. And so,
which they're almost always going to want unless they're a cash buyer.
Unless they're a cash buyer. And so, from a financing perspective, lenders don't, for numerous reasons, they don't want to lend when the buyer is not shown as the buyer on the purchase contract. And it's an assigned purchase contract that just doesn't fit within the lender's box of what they want to lend on. And so a novation opens the door for, because the contract that's actually being used is going to reflect the buyer as the end buyer as the buyer, and is not going to be an assigned contract. It's not an assigned contract. I mean, that's one of the major differences is there's no assignment in a novation. It's a replacement. And so in that case, that secondary contract, a lender is, and I'm not a lender, if anyone's listening to the show, do your due diligence on this. But my understanding is that lenders are more likely to underwrite and lend on those contracts because it's not an assigned contract and the buyer is listed as the actual buyer.
So your end buyer is a major factor as to which direction you're going to go. Which transaction is better for the initial seller? Is one more convenient or one more disruptive to the seller? And that should be something you want to be aware of if you're kind of a investor who's buying the property to either wholesale or novate to another end buyer?
Yeah. So in that case, generally a novation is going to require a little bit more work on the seller's part. In the wholesale scenario, the buyer has the ability to assign the contract. You have an assignment, everything's processed, and then the seller's notified, hey, come sign the closing documents and then get your check. That's a wholesale.
If they've already performed on the front end of that deal with disclosures and all of those things, and it's just assigned 3 days before closing, it's just a name change, but there's not a whole big difference to that initial seller.
Correct. Versus a novation, it's a contract between the seller and the new buyer. And so, now some investors do novations with attorneys in fact, powers of attorney, those types of things. Ultimately, the seller has to sign to close the transaction. But my preference is to have a good relationship with the seller and to have the seller, sign the secondary purchase contract to, work with that end buyer as far as inspections, things like that. And so in that scenario, there is more work on behalf of the seller. I mean, the seller's having to, basically be involved in a secondary transaction and sign additional documents prior to the closing. And then they still have to show up and, sign the deed and settlement statement and all of that to close the transaction. And so so there is more work on the seller's part.
Sure. So as a real estate investor who is buying the property, there's a couple things. There's one, communicating with that buyer and on all the possible scenarios that might take place, but also transactionally giving yourself as many options as you can on the front end, because oftentimes you don't know who your end buyer is going to be as the real estate investor. It might be retail, it might be another investor like yourself. So let's talk about the difference in the documents between the two transactions and what that looks like. So why don't you spell out for us what documents you need for a wholesale transaction and the issues that pertain to that?
So for a wholesale transaction, you're going to want your initial purchase contract with all the proper disclosures. So we talked a little bit about the fact that here in Arizona, you have to have these special disclosures as far as, that you're a wholesale buyer, that you're going to basically potentially assign the contract, et cetera. So you have to have those in place on the purchase contract. So you have to have a purchase contract with proper state or other disclosures. Then you have to have a memorandum, but only if the purchase contract provides for the recording of the memorandum. So that's another critical thing. So the purchase contract should state that you have the ability, or the investor has the ability, to record a memorandum, which basically evidences the fact that they have the property under contract. And then you need an assignment with the proper disclosures, because we talked about this in our very first show, actually, which is this new Arizona law that when you assign a purchase contract, you have to disclose that basically you are not the fee title owner of the property, and that the ultimate success of the transaction may relies upon seller, cooperation, et cetera. And so you have to make those disclosures in the assignment as well. So you purchase contract with proper disclosures, a memorandum if allowed by the contract, as well as an assignment with proper disclosures for a wholesale transaction.
Now, we've talked about this in previous episodes, but I think it's worth fleshing out again, given that we're talking about a wholesale and assignments. But your garden variety assignment and your garden variety purchase contract are not going to be sufficient.
No.
You need to be thinking about how those two mirror each other and work together. Isn't that right?
Yeah. So that's a very good point. So your assignment and purchase contract need to work together. And one of the main things that you want is you want your assignment, because you're always worried about the end buyer performing, right? So you want to make sure that your assignment states that if that end buyer fails to close by the closing date set forth in the contract, or if you have a closing date set forth in the assignment, which should be the same or within a day or so of the closing date in the purchase contract. But you want it to basically say in the assignment that, hey, if you don't close by this date, you're out. This assignment's terminated, canceled. You have no further right, title, or interest in the purchase contract, in the property, et cetera. And your earnest money is gone, basically. And that's what you want the assignment to say, is it's an immediate termination. You have no right to benefit from any cure notice, et cetera. So an assignment is basically a transfer of a bundle of rights to your assignee. So the assigner says, I have all of these rights under this purchase contract, and I'm going to assign this bundle of rights to you as the assignee. Well, basically, you want to pull out from that bundle of rights the ability to receive a cure notice for a breach. You pull that out and say, okay, I'm going to assign all of these bundle of rights with the exception of your right to receive a cure notice. Because if you don't pull that cure notice out, then you assign all the bundle of rights, which includes the right to receive a cure notice. So let's say hypothetically, you're supposed to close on December 31st, and you get to December 31st, and the end buyer's like, I don't have it in order. And you're like, okay, well, you're out. And they say, well, wait a minute, you assigned the purchase contract to me, and the purchase contract says that the seller has to cure before this is canceled. And I want my rights under the purchase contract that you assigned to me pursuant to this assignment. And you know what? They would get that right. They would have that right to wait for a cure notice. So you want to pull out that cure notice. So the assignment is going to basically say, hey, if you don't perform by December 31, you're out immediately. No right to a cure. But then you want your purchase contract to have a cure notice. For example, I like a 10-day cure notice, which then the seller has to then send out a cure notice and say, hey, you didn't close escrow by December 31st. You have 10 days. Well, that, whether you can or can't, I don't know. And it just depends on the market conditions, as well as price and all that good stuff. But at that point, you have 10 days to find another buyer. If you can find another buyer in 10 days, rescue this thing, great. If you can't, you may end up losing your earnest money, your original earnest money, although hopefully you've made it up with the earnest money on the assignment. So you're basically break even, but you want those to work in conjunction, because if they don't work in conjunction, then you're sitting there as the original buyer and assignor of the purchase contract, kind of twiddling your thumbs like, oh, are they going to perform or not? And you don't really have the ability to say, you're out. Let's move on. Let's find another buyer. Let's see if we can rescue this thing.
I think where a lot of people go wrong with the assignment is it starts with wanting to move fast on a deal and not wanting to put the time into reading the agreement or even understanding the agreement, because maybe you're trying to save money and not work with lawyers. Who knows? But oftentimes contracts are lengthy and they have all kinds of boilerplate language. And, that's good in one sense. You can use a form and chances are the boilerplate covers something. But assignments are very simple oftentimes. You do not need any more than maybe 3 sentences to effectively assign something.
Correct.
I mean, and that's nice. You don't need a lot of language to do it. But a lot of people, I think, get a form assignment and that's all that it does. And it wholesale sends, the entire bundle of rights. And in this case, we're often advocating expand the amount of rights that you want under a contract. Well, in this case, you're really wanting to restrict what you're sending. So just your form paragraph assignment is not going to be sufficient.
That's exactly right.
All right. So those are the documents that you need to be looking at least in Arizona, for purposes of a wholesale transaction. Let's jump over to a novation. So we've considered our end buyer. Our end buyer is a retail buyer. We want to do a novation. How do we need to document that?
Yeah. So for your, for what you need for a novation, number one, you need a purchase contract with proper disclosures. Because like we discussed, you may want to, your disposition may be a wholesale, or you want to open the door for the ability to novate if that's possible.
Well, the one thing that is the same, now you haven't listed all the documents, but for both the wholesale and for the novation, you've stated a purchase contract. So in either one of those cases, you are using a purchase contract.
You're using a purchase contract, and it can be the same purchase contract. The only difference would be that if you think that novation's an option, you can add to the purchase contract a novation addendum, which basically says, I always have the right to assign this contract, but I also, if another buyer comes along and be, buying it, or they need to, or requiring to enter into a purchase contract directly with the seller, that I, as the original buyer, may allow that under certain conditions, basically.
Right.
And so that's what the novation addendum says, is basically that the seller, if this other buyer comes along, seller's going to cooperate, you're going to cooperate as the buyer, and you're going to basically novate. And here's what it looks like to novate, to replace that contract. So then you need a memorandum. And this is critical in novations, is you have to have that memorandum. And it still needs to be allowed by the purchase contract. So the purchase contract should say, that you have the right to record the memorandum. And the reason why the memorandum is critical is because basically that's what protects you from just having your purchase contract canceled and the seller closing with the buyer and you receiving no compensation for the cancellation of your purchase contract. Because that is one of the main differences between a wholesale and a novation, is how you're compensated. In a wholesale, you're compensated via an assignment fee. In a novation, you're compensated for canceling your contract. See, as a buyer, you have a contractual right to buy that property. Well, if there's this other buyer out there that wants to buy it, well, you have a greater right to purchase it because you're first in time in that original contract. So the way you're being paid is that buyer out there, or the seller, as part of the seller proceeds of that second contract, when it closes, they're going to basically pay you a cancellation fee. So you're going to say, okay, I'm going to cancel, or a release fee. You can also refer to it as a release fee, because what are you releasing? Your memorandum. But if you don't have that memorandum of record and you have a novation addendum that says, hey, yeah, if you find another buyer, I'll cancel my contract and I'll be paid. And then the seller runs out, finds another buyer, they close on that secondary contract, and they don't instruct escrow to pay you, well, then you're out. You may have a claim against the seller or something like that, but you might be out, depending on what the buyer knew or didn't know, all that good stuff. So the memorandum is what puts everyone on notice that you have a contractual interest, so that when the new escrow agent receives the file, they can look and say, oh, there's this memorandum out there. Was there another? Oh yeah, there was this other contract, and here's how they get paid. If I find this other buyer, then the contract is canceled, and then they receive either a cancellation fee or a release fee to release their memorandum. Then title calls the investor and says, hey, we're about to close on this other contract. Release your memorandum. And you say, okay, I'll release it for the payment of X amount of dollars that I'm entitled to under the novation addendum. And then they, are to write a check for that release or for that cancellation of that original contract.
Yeah, I mean, in either case, wholesale or no, I think it's correct to understand the compensation as being it both require a legal act on behalf of two sides of the deal, maybe even three sides of the deal, that they're not otherwise obligated to do. So in the assignment, we're compensating you to do something you don't have to do, which is to assign it. But it requires your act. If you were just to assign it without being compensated, well, then I don't need to pay you for it. I already have it. While on the novation, it requires an act, not only for me to accept a new contract, but for you to undo your old one.
Right.
So it's
yes,
it's the payment for that act to get out of the way.
Right. That's exactly right. That's how you're paid in a novation, is the cancellation of the original contract.
So after the novation, you've got the memorandum, the novation addendum. Anything else?
Yeah. So we talked about like the seller's cooperation and things like that. Well, one of the things you may want to do is have the seller execute some form of disclosure statement, because on a secondary purchase contract, especially if you're going to use some of the state forms, they're going to require that the seller execute some form of disclosure statement. So you could use the state form disclosure statement if the buyer is authorized, or there's a real estate licensee involved who's authorized to use that state or that realtor promulgated seller property disclosure statement. But even if you don't use that, there's nothing that requires that particular form be used. You could, have another disclosure statement that discloses everything material related to the property, and the seller, signs it and makes it available to, any future buyer. Also, title may require certain documents, like they want to see like identity statements. So for example, if John Smith is selling a property, well, there's hundreds of John Smiths. So if title goes and examines the recorder's office, they may see judgments from a creditor against John Smith. Well, they don't know if it's this John Smith or another, but if they have like the John Smith's date of birth and physical description and social security number, they can then compare it with the description in the judgment data sheet that has to be recorded with the judgment, and see if it's the same John Smith. Then they can, set aside a bunch of these judgments as not being applicable. So title may want that form filled out as part of that process too. So any required forms by title, and then also the seller property disclosure statement.
So those are the forms that you would use to transact this, a wholesale and a novation on the front end. What about forms used in the disposition of a wholesale transaction compared to those that you would use in a novation?
Yeah. So for a disposition, we've kind of talked about this. In a wholesale transaction, it's the assignment. as well as the final closing documents prepared by title. And that's basically it. There's nothing more. A novation, though, requires the seller to execute a new purchase contract and any corresponding addendums and disclosure statements if required, inspection notices, those types of things, and then also execute whatever documents title requires to finally close the transaction. So there's more work by the seller on a novation potentially, and it's that's why it's important in a novation to really have that good relationship with the seller, to let the seller know, what you're doing, how you're doing it. There's even some ways to structure the transaction to provide actually the seller with a little bit extra compensation in the novation process, and which would then give them some financial incentive to also cooperate. And there's ways to structure that as well.
That's why it's important too to already have their cooperation agreed to in the purchase agreement.
Yes.
Otherwise, you're going back and asking for permission.
Instead of saying, hey, you agreed as part of this novation addendum that if there's this other buyer and the purchase price is greater than or equal to, and the contract is on a realtor form, with the standard terms, and so now you have something to rely upon to say, hey, look, you've already agreed to this. We just need basically your cooperation or signature to move forward.
Hypothetical, what if your end buyer is a conventional buyer and you decide to use a novation and they enter into a new purchase contract and they saw that they had to do something unique like a novation, and they thought, well, this is really interesting. And prior to escrow, they realized, well, wow, people are assigning these deals and they're novating to new parties. And oh yeah, I've got this cousin Vinny who's also looking for a new home. Why can I just assign it to him? Is there anything stopping this buyer under a novation from assigning the contract to another party?
I mean, if in this market, it may prove difficult. But when
that would maybe last year that would have worked.
That might have worked, but assuming that the market conditions are right and you have the appreciation in the market like what we've seen previously, that's such a great hypothetical because it really is outside of the box, right? When you think of novation, you just think of the three parties, right? The seller, the original buyer, and the replacement buyer. You don't think of, well, could the replacement buyer then assign the contract? So a few things would have to be in place for them to sell it. Number one, market conditions, or not sell it, to assign it. Number one, market conditions. But assuming market conditions are in place, then in Arizona, if it is residential property, then the purchase contract between the end buyer and the seller would have to state that the buyer is a wholesale buyer and who may assign the contract. If you don't have the disclosure that buyer is the wholesale buyer and they go and assign it, at that point, the seller by statute can cancel the contract and retain that buyer's earnest money. So Arizona's kind of changed the game on that, because the game used to be that a buyer could assign even if the contract didn't expressly provide for it, as long as it was not detrimental to the seller. So if everything was the same, the end buyer or the assignee of that purchase contract was going to buy in cash or obtain the same type of financing, and their financials and credit were about the same as the buyer assigning it, everything was pretty much the same. Yeah, you can assign it even if the contract doesn't say you can. But if the contract doesn't say you can assign it and doesn't disclose that the buyer is a wholesale buyer, then they can't assign residential property. Now, they could assign commercial property, vacant land, retail, those types of things. They can probably assign those types of properties, commercial properties. But residential, they probably would not be able to because of the state law here in Arizona. Now, that's not to say they couldn't do it in another state that doesn't have our disclosure requirements, but at least here in Arizona, if you plan to, or even intend or will be assigning that purchase contract, you have to have that wholesale buyer language.
All right, let's talk about remedies. We've talked in detail about what you need in the purchase contract to help give you the most flexibility on what you can and can't do as the buyer, the real estate investor coming in. But not everybody plans for every contingency, or not everybody goes and makes sure that their purchase contract has all of those things. But as a general rule, what remedies are available to the buyer if that seller, that first seller, says, "Whoa," you know, and let's say you did all the disclosures, right? I didn't appreciate that, or I didn't read it. No, I'm not okay with you assigning or novating to somebody else. I don't want to do this spuds again. I don't want to go through everything else. What are the remedies for the buyer?
So the remedies for the buyer is, assuming that the contract is documented correctly, it would be the same remedies for a seller backing out of a traditional sale, which is specific performance. Basically going into court and saying, "Look, judge, we had this purchase contract in place. It required certain duties, obligations, and performance by the seller. I, as the buyer, have not breached the contract, and the seller's not performing as agreed. And therefore, judge, I want you to force them to perform." And in a specific performance action, if the seller still refuses to perform even after court order telling them to, then the court has a number of remedies at their disposal, one of which would be to order the title company, or even order the buyer to execute whatever documents the seller is refusing to execute, and that the signature of those parties will be deemed and given equal legal weight and authority as the signature of the seller. So they can actually basically say, "Well, okay, seller, you're not cooperating. You're violating my court order. Therefore, I want the buyer to be able to perform on this transaction, and I want this transaction to close. And therefore, if you're not going to cooperate despite my telling you to, okay, buyer, you can sign for the seller, and that will have the same legal effect as the seller signing."
All right, so let's move to closing the transaction, novation or a wholesale transaction. Does it matter what title you use?
Yes and no. So anytime you're investing and doing transactions that are outside of, the ordinary real estate, even commercial transactions, there are certain title companies, agents, or others that don't have experience doing commercial because it's a whole different animal. So, even those, you're looking for a title company and escrow officer who has that level of experience and that level of knowledge regarding that type of transaction. And the same for these more creative transactions. So, your creative finance, your wholesale, your novations, you want a title company that knows the investment space and knows the different structures of these unique transactions and how they work, and the documents that are necessary for them to work, and what a settlement statement looks like at the end of these transactions, and who is paid what and how are they paid, and those types of things. You want a title company that's aware of that. So I recommend that you do search for and seek out a title company that has experience doing novations. However, let's say the buyer and seller get together, the end buyer, right? And they get together and they decide, "Oh, we want this title company." You can't stop them. But that's where the memorandum comes in. Because even if they go to that other title company who you're like, "Oh, I don't know," because they may not have experience doing, novations, um, you still have a memorandum out there. And so, when the time comes to close, that title company is going to be reaching out to you, and you're going to say, "Oh yeah, under my novation addendum, here's how I'm compensated to have canceled my original contract or to release my memorandum." and here's my, invoice or fee to release this memorandum, and you title company and here's my release, and you're authorized to release so long as out of the transaction I'm paid X amount of dollars.
Yeah, it's important to be thinking that on the front end too, because if you're just dealing with a seller who has a real estate agent and they're just conventionally listing the property, usually those purchase contracts, well, of course, they're a form purchase contract they're using, but they've already filled in typically the title company that they're planning on using, just because maybe that agent is used to working with that title company or whatever else. But that says nothing about whether that title company does anything outside of a conventional deal, whether they understand the difference between a wholesale, an assignment versus a novation, and whether you're going to run into a sticky situation there.
Exactly. Yeah. Under RESPA, there's certain restrictions as far as, who can choose and how you choose the title company. But the preference would be for the parties to agree and to have that final contract, that replacement contract, closed by a title company that's familiar with the novation process. It'll just be generally it'll be a smoother transaction. So yeah, it's important to think about that on the front end and hopefully have that in place. But you as that original buyer, you can't dictate that. You can suggest it. You can, try to navigate that. But at the end of the day, the seller has some say in where escrow is open, but then the buyer who's obtaining the title insurance, the end buyer has the ultimate say on who provides that insurance product. That's RESPA.
So given the number of assignments, wholesale transactions, novations that you've done, with that knowledge base, what one thing have you come away with? And I know there's a lot of things and they're all important, but if you're talking with the new investor that's wanting to get into this, maybe they're planning for the next time, or working into dealing this at a much larger scale, what do you think is the most important thing for them to begin planning to do in a kind of a wholesale and innovation space?
So number one, have your documents in order, and have your documents prepared and drafted in such a way that once you have a purchase contract signed, it can open the door for different disposition strategies. So, one purchase contract can work, and the same purchase contract can work for a wholesale and a novation and a double escrow. So any of those strategies will work. Now, a double escrow will accomplish the same thing as a novation. Like you said before, though, the main problem with the double escrow is the double closing costs, number one, but then also the logistics of it, right? You have to have the resources to close that first transaction. Versus a novation, you don't. A novation, you're only doing one escrow, and then the original buyer's compensated because of that cancellation or release. So both of those can accomplish the same thing. It just depends on which one you think will work, and whether or not you have a cooperative seller and whatever, because you don't need seller cooperation at all on a double escrow. All you need is the seller to show up and close the original transaction. They don't have to cooperate at all during the process. They just show up, sign whatever they need at closing, and then they don't even know you're double escrowing it because you're going to do that 24, 48 hours later. A novation, though, avoids that, right? A novation avoids the double escrow, but accomplishes the same objective, which is, an end buyer ultimately, purchasing the property for close to retail value. But I think the biggest thing, and if I had one piece of advice, is have a purchase contract that will allow you to do any of those strategies, and pair that, if you're going to, with an assignment that, gives you a level of protection in a wholesale that maybe you wouldn't have if you, for example, assign the full bundle of rights.
It's all about the purchase contract and forms.
Mm-hmm.
You're welcome, folks. We just saved you decades of pain and misery. But it really is just that simple.
Yeah.
And it's not even as difficult as one would think. It's just being thoughtful on the front end
Yes.
rather than just running into a deal like a chicken with your head
Right.
cut off.
Finding that 2-page purchase contract online, having it signed, and then being like, okay, where do I go from here? No, that doesn't work. You need to have a contract that provides all the disclosures that you need to provide for the nature of the transaction, has whatever addendums you need to have, but allows for a number of disposition options available to you.
All right. With that, folks, that is our episode. We trust that you found that valuable. Make sure to join us next week. We're going to be talking. The topic next week is Arizona's hot, but is the real estate market. We have as our guest Tina Tambor from the Cromford Report. That should be good. Make sure to tune in to get information on Arizona's real estate market. We'll see you next week.
Have a good day, everyone.